get started on time. So why don't I start things off? Hi, everybody. Welcome to the fourth and last in this spring's series of Anderson Legislative Seminars. We are online for the fourth and final session, and I'm grateful to everybody who's worked to make this possible. I especially want to start out by thanking Bennett Liebman, who's organized this event. Bennett decided he would rather be in the audience enjoying the event, and we're grateful to him for all the work that he did. I'm also very grateful to the sponsors of our program. The series sponsors are the Rafay Group, PC, and a donation in memory of Sharon P. O'Connor, Albany Law School class of 1979. We're also grateful to today's program sponsors, Greenberg Traurig LLP and Brown and Weinrob PLLC, as well as CSEA and Hinman Howard and Patel. So before I turn it over to Richard, who's our moderator for today, just a couple of words about how this is going to work, functionally speaking. I'm going to be making sure the technology works and taking questions over the Q&A function. So to everyone in the audience, if you find you have questions, please submit them at any time. You'll find that if you move your mouse around, there's a button at the bottom of your screen that says Q&A. If you click on that button, you'll get a window that you can use to submit questions. I'll be reading them, and at the end of the panel, Richard will be calling on me to read or summarize the questions we've gotten from the audience. I may interrupt the panelists if there's something that somebody raises that seems particularly in need of clarification. There's also a chat. Anyone in the audience can communicate through the chat, particularly if you're having technical problems or if there's something that I can help you with during the conversation. I also want to note that for many of you who want CLE credit, if you're an attorney, the code you'll need for verification is, let me just make sure I have it right before I say it, GIG20. That's capital G, IG, number 2, number 0. You don't have to worry about the capitalization. And we can tell who's been on the call thanks to Zoom's magical internal surveillance features. I want to also say that this is not the end for the Government Law Center. If you're looking for more CLE credits, we have a program in Saratoga in August. Every Friday in August, there will be updates on the US Supreme Court, New York practice, New York evidence and ethics from Professors Bonventry, Hutter, and Connors. So be sure to watch for those. And again, I'm extremely grateful to everybody who's made it possible to organize and attend this year's Anderson series. I know it's a strange feature of Zoom that those of you who are attending the webinar can't see how many of you there are. There's just about 100 people listening right now. We're grateful to all of them. And I do want to say, since this is the last Anderson, that this has been our first year doing it without Mary Berry at the helm. Mary has been a wonderful part of the Government Law Center's life for many years, and of the Anderson Breakfast series in particular. So I just wanted to say thank you to her for her many years of dedicated service to this program, and we hope to live up to her example and expectations. So with that, let me turn it over to Richard Rifkin, who's going to be today's moderator. Richard, over to you.
Okay, thank you, Ava, and good afternoon, everyone. Welcome to our program on the gig economy. During the 20th century, the concept of the employer-employee relationship, which had long existed, was legally recognized in the adoption of many federal and state laws. Collective bargaining was structured and guaranteed. Government assistance programs were enacted, such as workers' compensation, unemployment insurance, and worker safety rules were established. In addition, employee benefits beyond salary, benefits such as health insurance and pensions, became common, especially where employers had a large number of employees. All of this was well established as we entered the 21st century. In the span of the last 20 years, much has changed. Many workers now have very different relationships with the companies for which they perform services. These relationships vary in many ways, and we are only beginning to understand how this will play out. Certainly, the economic crisis resulting from the COVID-19 pandemic has increased our attention to these new forms of relationships. The shorthand term for all of this is the gig economy, and that is what we will explore this afternoon. Laura Schultz, who was very recently named as the Executive Director of Research at the Rockefeller Institute, will open our program by defining for us what we mean by the gig economy, a matter that is far too often overlooked as that term is used. She'll also try to give us a sense of the extent of its use in our economy today. Frank Curbine, who is director of the Center for Human Services at the Business Council, will next focus on the gig economy in New York State. He will cover its uses in this state, as well as both current and proposed legislation and regulatory activity. Veena Duval, an associate professor of law at University of California, Hastings, will next cover the same issues as they have developed in California. Excuse me. Finally, we'll hear from two speakers with different perspectives. Josh Gold is the Director of Public Policy and Communications at Uber, and he can share with us the views of a company that has been closely associated with the gig economy. Our final panelist will be Terry Gerstein, the Director of the State and Local Enforcement Project at the Harvard Law School and Work-Life Program. She will offer her thoughts about the impact of the gig economy on the workers, including the impact of the COVID-19 shutdown on those workers. So with that, let me get to the experts on the gig economy, and I turn this over to Laura Schultz.
Thank you, Richard. And thank you for the invitation to present today. Let me share my screen. I have a few slides. I am from the Rockefeller Center of Government, and last year we launched the Future of Labor Center. And our goal is to bring an interdisciplinary team of researchers together to study different aspects of the changing nature of work. We want to understand the implications for the workers, the employers, and the communities they live in, and how labor and employment policies will need to adapt for the future of new kinds of work. And here is an example of some of the work that we have done. And today I'm going to be talking about the report that we recently put out on defining and measuring gig work. As Richard mentioned, we have traditional employees. These are people who report to work during hours designated by their employer. They have a working relationship with their employer. The employer sets expectations, has a set rate of pay, benefits, and there are labor protections. Everyone else is considered part of the gig economy, and there are a lot of terms that get thrown around for this group: self-employed, independent contractors, freelancers. This includes electronically mediated employment, and economists look at these as alternative work arrangements. And there have been a large number of studies over the last 3 or 4 years that look at how big this gig workforce is. And their estimates range from 10 to 36. So how do we get from 1/10 of our economy to over our workforce to over 1/3 of our workforce participating in the gig economy? And so I want to talk today a little bit about what goes behind these numbers so that you can have a better sense of what we're talking about or what you're reading about. There are a number of different ways to measure this. Most of them do perform surveys of households, asking them how people are employed in that household. The IRS has started to issue a series of reports that look at tax documents, if you bring home, if your income comes from a W-2, you're considered an employee. If your income comes from a 1099 form, then you would be considered part of the gig economy. And then others have looked at bank account activity to see if people are receiving funding from electronically mediated employment. The nature of the work is a big factor in how big these numbers are. Government surveys, for the most part, ask people about their primary job. So where do you earn the bulk of your money? Where do you spend your hours? And if you ask only about primary employment, you aren't asking about people's part-time jobs, perhaps working on an online platform, or maybe they are an adjunct professor or work in a temporary job for part of the year. And you can look at the findings and see that including secondary or occasional work almost doubles the size of the gig workforce. The time frame matters. Government surveys ask about what your employment was over the past week, but if you ask about the previous month or over the course of a year, you're going to get much larger estimates. And the Bureau of Labor Statistics is the primary source of all employment data in the US, but then IRS, Federal Reserve, and several private companies have started to mine their data to look and examine the gig workforce. So what struck me when I was looking through all of these studies is there is no consistent regular data collection on exactly how big the gig workforce is in the US. But there are some standards. About all of these studies have looked at 5 different categories of gig work. And I want to just do a quick run through of what those are. The largest segment of the gig workforce are the independent contractors. They are someone who provides a good or service to customers. They have to seek out their own customers. The Bureau of Labor Statistics estimates that's about 7% of our workforce earns their primary income through independent contract relationships. In general, it's about 4 to 10% of our workforce, but you can see with Gallup and with the IRS, when you try to figure out who earns it as secondary income, it does increase the numbers significantly. On-call workers are the second largest part of the current gig workforce. These are people who only work for an employer as needed. Substitute teachers are the biggest category of this, and they account for about 2 to 4% of the workforce. Healthcare is another big segment for this. Contract firm workers are considered part of the gig workforce. These are individuals who are employed by one company but work at a client company. This is very common in janitorial, landscaping, security services, and IT services. But there's a big definition problem with this sector. If you are employed by a janitorial contracting firm, you receive a W-2. So those individuals would likely consider themselves employees and not necessarily gig workers. But we're looking, so that's why we have a large range of anywhere from 1% to 10% of the economy. Then we have temporary help agency workers. These are people who find short-term employment through temp agencies. But then at the same time, again, we can have a bit of a measurement issue. Gallup, one of the big surveys, finds about 7% of the workforce is a temp worker, but they don't clearly define what a temp worker is, and that probably includes people who just do seasonal employment. But I think the part that is of most interest to a lot of economists and is the biggest emerging field are the online platform workers. They're also called digital marketplace workers, the electronically mediated employment. These are individuals who rely on online platforms to find short-term employment. So these are generally put into 4 categories. These are people who transport people or products. So that's Uber, Grubhub, DoorDash. Then you have the segment that does other work. So TaskRabbit is where you go on and find a handyman. selling goods and services through an online platform can generate income. So Etsy, eBay, and the question is, should some of these people be included in the workforce? Oh, should be part of the workforce. If I am unloading my collection of Christmas ornaments from the 1950s, is that really considered part of the gig workforce? And then finally, you have the individuals who lease property through sites such as Airbnb. The most recent BLS survey found that about 1% of all workers in the US, 1% of all households surveyed, 1% of people had participated in the online workforce in the last week. If you look at the past year, as some studies do, that goes up significantly because people go in and out of that workforce as needed. And that's one of the features of that workforce. But what you do find is that the studies from 2016 have much smaller numbers than the studies from 2018, indicating that it is increasing rather quickly. State level data is hard to come by in these studies. The IRS calculates about 10% of New York tax filers are participating in the gig economy, and in 2016, less than 1% were in the platform economy. The census did household surveys and find 10% participate in the gig economy, but 18% when you consider full-time and part-time employment. But no matter what comparison, New York shares tend to be about 2% below the national average. So New Yorkers are just less inclined to participate in the gig economy than the all Americans as a whole. But because New York is a relatively large state, it is one of the biggest, has one of the biggest gig workforces. So the takeaways are, we know that the nature of work is changing, but we really don't have the data required to really fully understand those changes. We need to work on standardized definitions of what's included in the gig workforce and what subcategories we want to look at. We need to integrate secondary employment into this. The data needs to be collected on regular intervals, and we need to start looking at state levels too, because there's big variations among the states. Ultimately, I think we want to better understand how big the gig workforce is, what types of protections they use, and then just in general, what are the trends over time.
Laura, that it's very interesting to try to deal with these definitional problems, which are much more difficult, I think, than most people realize. Next, we have Frank Kerbine, who's going to talk a little bit about what's going on in New York State. Frank?
Thank you, Richard. Thanks for having us. Everybody, the Business Council, for those who may not know, is the State Chamber of Commerce. So I represent businesses, employers across the state. So we certainly have an interest in this, as you can imagine. As Laura mentioned, it's a large portion of the workforce, estimates up to a third, as you described. So this is no small topic, and it goes beyond just the Uber, Lyft, DoorDashes of the world. It applies to a lot of the other freelance type work that's out there. I'm not a lawyer. I'm an HR professional by trade. I've been doing this for 35 years or so. I'm part of the government affairs team I'm a lobbyist at the Business Council, but the good kind. And so when I look at this legislation, I try to approach it from the perspective of the HR professional sitting behind the desk and how we're going to address this. And one thing that's clear is, as Laura mentioned, that the nature of work is changing and there's a lot we still don't know. But I think one thing that's clear is that it's really impracticable to apply 21st century innovation that these amazing companies have come up with, have to apply 1930s era labor law to these situations, especially in New York State, which is one of the most regulated employer-employee relationships in the country. I understand the desire of regulators to regulate. It's their nature. And we want to protect employee rights. We want to be able to have, at the same time, a business climate where innovation is encouraged, where businesses are looking to relocate to New York State. New York State has an issue with trying to attract and retain businesses We don't want to adopt policies that are counter to that. And again, merely applying the current definition of employee to more workers isn't innovative, creative, or new. It's really an unimaginative approach, kind of parochial, serves certain special interests. I'd argue that maybe organized labor is a beneficiary of this type of sledgehammer approach to this nail problem. With their declining membership, that they're looking for other opportunities for increased membership. So how these third-party intermediaries, I'll refer to them as, can apply current labor law to this new workforce to me is strains credulity. So we in the Business Council have been arguing for a third way, merely stamping a new definition on a worker and applying the current laws. We think is highly ineffective. In New York, for example, let's take unemployment insurance first. We have had the New York State Department of Labor rule on more than one occasion that individual drivers of ride-sharing services are considered employees for the purposes of collecting unemployment benefits. We understand that they were looking at the concept that their earnings and wages would qualify them for benefits, but how we would ever determine that an individual who can freely turn off an app and remove themselves voluntarily from the labor market is eligible for benefits under the system, a system designed to provide benefits for those who lose no job through their own, is something that I can't wrap my head around. How we're going to, if someone turns off the app, I'm no longer in the gig economy for a period of time. How are my benefits calculated? How am I voluntarily separated from the labor market? An interesting side note, New York State during the COVID pandemic had a little interesting dichotomy arise here. As I mentioned, the DOL had ruled that these individuals were employees. However, under the Pandemic Unemployment Insurance Assistance Act, part of the CARES Act, the federal government was going to pay for the benefits provided to independent contractors. You could see the Department of Labor then changed their perspective on this. And I think for the course of the pandemic is considering these individuals independent contractors, the result being that the feds get to pick up the bill on this. Wage and hour law, I don't know how you measure hours worked. I mean, as HR professionals, we spend a lot of time and effort trying to make sure employees clock in, clock out, that timesheets are accurate. If I'm an individual participating in this economy, is the app, when the app is on, am I engaged to wait? Am I waiting to be engaged? These are important definitions under the Fair Labor Standards Act that I don't know that can be resolved using the Fair Labor Standards Act from 1938. And what if I have multiple apps open? If I have an Uber app, a Lyft app, a DoorDash app open, which entity is responsible for paying me a minimum wage based on hours worked, or calculating my overtime calculations based on hours worked? And they're not all about wages either, and measuring hours worked. The New York State minimum wage law, federal overtime wage laws require a broad array of record keeping in terms of when employees come to work, uninterrupted meal breaks, eligibility for paid family leave. There's a million things that are based on this record keeping that seems impracticable with the current system. Workers' compensation comes up. Setting aside the argument about liability of someone working off premises and using their own equipment, et cetera. There are other ways to address workplace injuries above and beyond the normal workers' compensation system. And we think that there are a third way and innovative ways to do that. Regarding collective bargaining, I mean, the National Labor Relations Act, 1935, again, another one of these 1930s eras laws that would be applied to determining mandatory and permissive topics of bargaining, appropriate bargaining units. Again, if I have multiple apps open, whose bargaining unit am I in? Is this a lawful or unlawful work stoppage when we all turn off our apps on this particular day? Again, applying the current law would be impractical. And again, we say this because that seems to be the approach that is being taken. We'll look at California, and we have someone who will speak on that much more knowledge than me later. But it was a change in the test, right? We're going to take the test. We're going to net result increase more individuals be considered employees and apply, assuming the regular rules and regulations would apply to them. We certainly concede that no worker should be discriminated against in the workplace, harassed in the workplace. Civil rights protections clearly should be part of any third way going forward. We believe that benefit pools, some of them already exist. We have a black car fund in New York State that provides some protection to platform users. Are ways we think that third-party intermediaries are uniquely positioned to provide this type of pooling services. We could see things like auto insurance pools, disability insurance pools, things like that, facilitated by these third parties. And as innovative as these companies are, they've been innovative in this field. We have a lot of these platform-based organizations that are doing just that. They're coming up with ways to provide income protection for injuries occurring during the workplace. They're coming up with ways to talk about minimum income guarantees, things like that. This innovation will happen organically and on its own. Health insurance is a topic that comes up frequently. New York State has achieved almost universal coverage anyway. We're only 4.5% away from having everybody covered in New York State, and there are systems in place to do that. So what we're looking for is this third way, to try to address this new market, to encourage innovation, to not set New York State apart as a barrier as a barrier to good business development. New York State, as you know, has well-documented financial issues, a net loss in population year over year. It's a challenging business environment in New York State now, and merely changing a definition, consider who's a worker and who's an independent contractor would have a significant impact. So any unilateral action by New York State would have, I think, significant detrimental effects to our overall economy, an economy that is in rough shape as we speak. So we propose a federal solution to this. We would need to change the National Labor Relations Act, the Fair Labor Standards Act, Income Retirement Security Act. We're open to changes like this that take into account the new dynamics of this workforce. The New York State acting on its own unilaterally could lead us down a path of some short-term pain before we get to the desired results of employee protections.
Thank you very much, Frank. Now let's hear about what's going on in California. We can compare it to New York. Mina Duval, you're up.
Hi, so I am a professor of law, and for the last decade, I have studied what we now refer to as the gig economy. California is most being discussed in this context right now in reference to this AB 5 law, which I'm going to get to shortly, but I first want to give you a brief history of gig work in this state. So prior to my research on Uber and Lyft drivers, I did research on the offline gig economy, that is taxi industry, and specifically when the sort of regime of employment and labor laws that we currently have was passed during the New Deal, there was actually no carve out for independent contractors. The independent contractor carve out came as a result of really creative lawyering and business lobbying in the late 1940s, and was actually, at least in reference to the Social Security Act, was vetoed by then President Truman, and then his veto was overridden. But you know, after this sort of option became available for independent contractors to to exist without any protections, without minimum wage protections, without unemployment insurance protections, businesses started to creatively experiment with ways to avoid the expenses associated with labor costs. And so one of the first industries where that happened was, of course, the taxi industry. And literally the taxi companies, the work was the same from day to day, but the taxi companies wrote to the IRS and they said, hey, if we start asking our workers to buy or to rent the taxis per shift as opposed to sharing commissions with them, then will we have independent contractor workers? And the IRS said yes. And that is slowly how the taxi industry was deunionized and how workers lost unemployment insurance and workers' compensation as a result of the fact that the unions had lobbied for and gotten supply curtailed through the issuing of licenses, and also had fare regulations. Taxi workers were able in the San Francisco Bay Area, through direct lobbying of their municipalities, to create some semblance of security in their lives, some semblance of wage security, although it was limited. Then in 1989, the California Supreme Court decided S.G. Borrello and Sons, in which they examined whether sharecroppers picking cucumbers for growers were independent contractors or employees of the grower. And in deciding that they were employees, the court laid out an 11-factor test. Now, this 11-factor test is rooted in the common law of agency test. Now, you recall I said that when the social safety net was legislated during the New Deal, there was no carve out for independent contractors. And that really is because the idea was that all workers, in the context of vast inequality in the Great Depression, all workers needed basic safety protections. And so when the independent contractor carve out sort of was infused into the regime of employment and labor law benefits, the definition for who an employee was really about control. It was borrowed from tort law. It was about if the employer or the hiring agency was retaining the right to control the means of the manner of performance of the putative employee, then it was more likely that the employee was or that the person was an employee. And so that's what Borrello was based on. And it was this 11-factor test that looked at whether or not the work was part of the company's regular business, whether the company provided the tools, whether the person performing the work was engaged in an occupation or business that is distinct from that of the company. And so after Borrello was passed, there was actually a lawsuit, a class action lawsuit against the major taxi cab companies in San Francisco, and of course the taxi workers won. And between 1989 and currently, workers have access to unemployment insurance and workers' compensation. And then of course, circa 2012, Uber, Lyft, and Sidecar in their current familiar format hit the streets of San Francisco. Under Borrello, for the past, 10 years, 8 years, Uber and Lyft drivers who sought unemployment insurance and workers' compensation, who sought back wages from state administrative agencies, many of them got these things. They were determined to be employees by the state agencies under the right to control test. But court decisions sort of pushing back against this business model of misclassification were averted because the companies sort of settled left and right, and of course relied on arbitration agreements to prevent decisions on the merits. And then in April of 2018, the California Supreme Court decided another offline misclassification case called Dynamics v. Superior Court of LA, in which an offline courier was determined to be misclassified for wage purposes. And in making this determination, the court decided that the more appropriate test was not the one decided and defined in Borrello, but rather the ABA ABC test. And the ABC test was, of course, not new, but actually used in workers' compensation statutes since since the 1940s, and in other jurisdictions in a variety of other contexts. And the idea that the court put forth was that the common law test invariably led to inconsistent determinations for the same kinds of allegations. So you see, for example, there's this really interesting comparison that I write about where you see FedEx v. NLRB in the DC Circuit, same set of facts, and then you see Alexander v. FedEx in the Ninth Circuit, and you have a completely different opinion, both based in the common law test. And so there are these inconsistent determinations, a lot of fear and anxiety from the business community about, well, if these two jurisdictions decide something very different about our workforce, where does that leave us? Also from the perspective of workers who don't know whether they have basic employment law protections. And so to counteract these inconsistent determinations, and to really look at the purpose behind employment and labor laws in California, the Supreme Court put forth this ABC test. They turned to this test, and the court really beautifully wrote that they were doing this, quote, to ensure that such workers are provided at least the minimum wages and working conditions that are necessary to enable them to obtain a subsistent standard of living and to protect the workers' health and welfare, end quote. So under the ABC test, which actually, much of which was actually embodied in the Borello test already, there's a presumption of employment, and if a company wants to hire an independent contractor, then they have to prove that the worker is free of control and direction, and they also have to show that the worker performs work that is outside the usual course of their business, and that the worker is customarily engaged in an independently established trade or occupation. And of course, it is the second point here that becomes most critical, because the gig companies want to say that they are platform intermediaries and not transportation companies or not food delivery companies. So what happened was the gig companies in California, immediately after the Dynamics decision came down in the California Supreme Court, tried to create an exception for themselves through legislation, which failed in that legislative cycle. And then in the next legislative cycle, instead of waiting for the companies to come up with their own law, the legislators decided to codify the Dynamics law into statute. So it's not just Supreme Court precedent, but actually codified into the labor code. And this, of course, this is AB5, and this set off a flurry of lawsuits and mobilizations. A number of actually people who sort of think of themselves as creatives, as freelance writers, as translators, felt that they were losing work because of the law, because of course, as a result of the fact that people live in one place, but their employer is in another state, and they're sort of doing work online, means that the employer can just then go to another state where it's cheaper to have cheaper to hire people. And so their mobilization led to a corrective called AB 1850 in this past legislative session. It just emerged from committee with broad support and will likely pass. And that law created exemptions for a number of creative professions, including photographers and photojournalists and freelance writers and editors, newspaper cartoonists. And it also critically clarified that the business-to-business exception or exemption in the AB5 law could in fact apply to individual workers who were businesses. Actual businesses. And then the California Trucking Association got a preliminary injunction arguing that AB5 was preempted by FQAA, the Federal Aviation Administration Authorization Acts, which preempts state and local regulation that has any significant effect on prices, routes, or services of motor carriers. And the argument there was that requiring us to pay our drivers the minimum wage, or providing workers' compensation or overtime will actually ultimately impact trucking prices. But perhaps most centrally for our discussion, Uber and Postmates sought a preliminary injunction at the end of 2020, sort of a loser last-ditch lawsuit. They argued that the law was irrational and unconstitutional, and that it was sort of unfairly targeting them. They did not get that injunction. Since the pandemic, we've really seen the ways in which this business model, which doesn't allow for a minimum wage, overtime protections, workers' compensation, and unemployment insurance. And I should say many things have changed since the 1930s, but human need has not changed. People still need basic wages. They still need to not be working 60 hours a week. They still need to have workers' compensation when they're injured, and they still need unemployment insurance. And so this really came to fore during this pandemic, where we found that all over the country, Uber and Lyft drivers were very confused about what to do. They had the companies via their apps tell them and encourage them to apply for pandemic unemployment insurance, and Dara Khosrowshahi even saying that, oh, you're getting this pandemic unemployment insurance because I lobbied for it, but many of them were eligible for state unemployment insurance. And the reason that this matters is because there is significant financial difference between state unemployment insurance and pandemic unemployment assistance. So, for example, I was helping a Lyft driver file for state unemployment insurance in California. His gross income was $45,750 a week. State unemployment insurance benefits are determined by gross wages. So if the state agency followed the law, then he would have gotten $440 a week plus the $600 in the pandemic unemployment compensation. If, however, he filed for pandemic unemployment assistance, which is what the companies were encouraging to do, he would have gotten $207 per week. That is a $240 difference in one of the most expensive places in the world to live. And this particular driver has 5 kids, caring for his elderly parents, and has been a loyal Lyft driver for the past 5 years. So, a really meaningful difference between what the federal government was offering in the short term, and again, this ends at the end of the year, and what he was owed as an employee of Lyft in the long term. But because of the reality that the federal government through the CARES Act was paying for pandemic unemployment assistance, and California was literally has nothing in their unemployment insurance coffers anymore, in large part because companies like these gig companies have refused to pay unemployment insurance taxes. The agency has been funneling people through PUA. So,
Lena, can I sort of cut you off and ask you to try to wrap up, because we're falling a little behind time-wise? I apologize,
sure.
but otherwise we'll go way over.
Sure. So, where are we now? Now we have a ballot initiative. So this is, this is the third way to get out from under providing basic protections to their workers. You have Uber, Lyft, DoorDash, Postmates, and Instacart have put on the November ballot an initiative which would exempt them again from the same law that all big employers have to follow, including Walmart and McDonald's. And it's probably the most anti-democratic ballot initiative that has ever existed in the state of California. If it passes, it will take 7/8 of the California legislature to vote to amend it. And in this initiative, driver waiting time is not counted as work time. Unreimbursed costs of driving while waiting for a ride are not counted. There are under-reimbursed costs steering drivers engage driving time. There is a healthcare stipend that will not apply to the vast majority of drivers. And you have UC Berkeley labor economists who have calculated that this initiative will more or less give workers about $5.64 per hour, roughly a third of the minimum wage of most large cities in the state of California. So while the companies have failed to even fulfill the promise of getting drivers in California who needed company prescribed sick leave, who they've put forth these self-regulations in the context of the pandemic, and the drivers I have talked to who have tried to get them have not been able to get them. So in the context of even failing to provide the basic benefits that they are saying that they are providing through self-regulation, they have spent over $110 million to carve themselves out of this law rather than to reinvent their business model and follow basic labor and employment laws.
Ina, thank you very much. Telling us what's going on the West Coast for those of us here on the East Coast. We've heard a lot of mention this morning so far about Uber. And rather than everybody just sort of talking about it generally, why don't we hear from Uber? Josh, you're on.
Awesome, thank you. Let me just share my screen. Can people see that?
Yes.
Fantastic, so it's loading for me. Well, I appreciate the opportunity to talk with you all today. I wanted to talk a little bit about New York's innovation. I think the question was posed to me sort of talking about the company's ability to innovate, but I wanted to talk about the New York State Legislature's innovation. New York has really, Albany, as well as the city and other parts of New York government have been leaders in innovation and finding new ways. And that's something that I thought would be a good topic to talk to this group about. So first thing, and I'm glad to hear Laura's chat at the top about the definition. I took just a report from the Center for New York City Affairs, which really focused on low-wage independent contractors. So if you took away, according to that report, the platform work, so DoorDash, Lyft, Uber, you would still be left with 700,000 independent contractors, low-wage independent contractors in New York. That's not including real estate agents, investment professionals, some of those creatives that we talked about, or maybe some of those creatives are low-wage workers, and others. And so it's important to think about the nature of work and the changing nature of work in context beyond Uber, Lyft, and DoorDash. There's a lot of conversations about Uber, but it's, as Laura talked about and as we've seen in this report and other reports, it's a portion of a changing workforce, and the need goes beyond the platform companies to try to figure out a way that you can innovate and provide some of those or many of those or all of those social safety net benefits in a way that works for this changing workforce. The choice between having your benefits attached to employment or having flexible work is a false choice. We can innovate, and New York has led that innovation, in fact, for decades. And so the legislative innovation I first wanted to talk about, which I don't normally talk about, but because Bennett Lehman invited me here, I wanted to talk a little bit about the Jockey Fund. I met Bennett either, I can't remember if it was talking about labor peace for casino workers or when I was organizing New York Racing Association workers a long time ago. So I thought it would be a good place to talk about the New York Jockey Fund. And that is one of the first innovations that I've seen in New York in this space, and that was back in 1990. And so you had many of the same questions we're talking about here come up in the realm of jockeys and their status, whether they're employees or independent contractors. But at the same time, you had jockeys who needed injury protection, who needed some form of workers' compensation. And you had states act first. California tried to copy from the employment system. It was seen by many in the industry as extremely expensive. Maryland, I believe, went next. Maryland made a program that covered only jockeys, not exercise riders, only during the races not during training, and it was very narrowly defined. New Jersey had a lot of confusion in their law that was hard for the industry to understand. And then in 1990, New York came up with a legal fiction. And what it basically said was for jockeys, apprentice jockeys, exercise riders, who are licensed in New York and riding on tracks in New York, they're employees of the New York Jockey Injury Compensation Fund for purposes of workers' comp. And all owners and trainers are required to pay into the workers' compensation fund. If Bennett was up here, he could talk about some of the emergency relief over the past couple of years that needed to go into that fund. But by and large, that fund provides workers' compensation for jockeys, for apprentice jockeys and exercise riders in New York through this fiction that jockeys are employees of the New York Jockey Injury Compensation Fund. Fast forward a little bit to 2000, again, about a decade before Uber exists at all. And there is a highly inconsistent ALJ rulings in New York on the status of black car operators, livery car operators, for-hire vehicle operators in New York. And the legislature, again, came up with an innovative solution. May sound familiar, but for purposes of workers' compensation, apparently I'm being spied on. For purposes of workers' compensation in New York, for-hire vehicle drivers are employees of the Black Car Fund. And in New York City, transportation network companies, which many of you know as Uber and Lyft, Via, are not able to operate in cities of 1 million or more. And so Uber operates about 25 for-hire vehicle bases, black car, luxury limo, and livery bases. And Uber drivers are, for purposes of workers' compensation law in New York, employees of the Black Car Fund. When the state decided to authorize transportation network companies outside of New York City back in 2017, they required TNCs to be members of the Black Car Fund, and all transportation network company drivers, so all Uber and Lyft drivers in the state of New York are members or are covered by the Black Car Fund for purpose of workers' compensation. They are employees of the Black Car Fund, and they get all the benefits that come along with the Black Car Fund. And so how does the Black Car Fund work? So it's not a surcharge on wages, it's a surcharge on the fare, and it's remitted to the BCF on a monthly basis. The BCF is self-insured, self-funded, self-administered nonprofit insurance company, and has the ability to tax Uber, Lyft, and the other bases. There are about 125,000 drivers. That was in 18. That number is probably more like 150,000 drivers through the old industry, as well as through TNCs and high volume for-hire services that are covered by the Black Car Fund to provide workers' compensation insurance. But it's not just the workers' compensation insurance. When you have a audited revenue stream and a captive group, you can go beyond that and provide additional benefits. And so in New York, the Black Car Fund has gone beyond workers' compensation, beyond the benefits of workers' compensation for all Uber, Lyft, and for-hire or black car drivers in New York, and started to offer additional benefits. So safety and training, drivers are paid to attend state-certified training courses. Drivers are paid to attend wellness courses to prevent injuries with prolonged time behind a wheel. There's a death benefit. There's no-cost telemedicine. There's first prescription drugs that are free. There are no-cost optical benefits for glasses and contact lenses. There's no-cost mental health services. And that was put into place over the past 2 or 3 years, but the state continuing its legacy of innovation in this space passed in 2019, Assemblymember Rodriguez and Senator Savino, and then some chapter amendments this year, which would allow the BCF to add additional surcharges to provide additional health benefits on top of what the benefits they're already providing. And so, right now, I believe the BCF is looking at free access to urgent care, dental care, additional benefits on top of that, and scoping those as that chapter amendment, I think the governor signed in April. But New York has led here in innovation and finding third ways to continue to cover, provide a social safety net that's funded, in a way that makes sense, that doesn't create a false dichotomy between employment status and independent contractor status. But it goes beyond that in New York. In New York City in 2019, the city passed a minimum wage for drivers that recognizes the ability for drivers to choose the gigs that are offered to them, and recognizes that ability and creates a minimum wage. Well, I have the wrong things up here, but in any event, New York's passed the high volume for hire service minimum wage and paid time off law, which under an independent contractor model has a minimum wage for Uber and Lyft driver via, and at the time Juno, which is no longer operating in New York, but has a minimum wage model. That minimum wage model in New York City, his goal is to provide $17.22 an hour plus $22,000 a year worth of expenses. And the way it was done is quite creative. The paid time off allowance is 90 cents per an hour for someone who's working 40 hours a week for 50 weeks. It's an equivalent of 15 days paid time off for Uber and Lyft drivers and Via drivers in the state of New York. You have a 28.7 cents per a minute requirement and a 63 cents per mile requirement. But because drivers are independent contractors, because there's a moral hazard associated with having a minimum wage, but also being allowed to reject all the trips that come your way, the city did something quite creative and took the company's utilization rates and used that, divided the time by the utilization rate to get to the rate you have to pay. It's based on how often vehicles are being utilized. And so if your vehicles are being utilized less, like Juno's were at the time, they have to pay more. If your vehicles are being utilized a lot, you can get, like Via is, you can pay less because you're being paid on a per trip basis. You're being paid more, you're getting more gigs if the platform is doing a good job in utilizing their vehicles. These all, by the way.
Josh, I just want to tell you, we're again starting to run short on time. So
this last slide, so I'm going to be done right now. These, by the way, are a year old. So there are COLA increases. So these numbers are 1.5% because unlike the minimum wage law for employees, there is a COLA increase baked into this formula every year. And so in New York, we've been able to figure out a way to provide workers' compensation, figure out a way to provide urgent care, mental health care, death benefits, now some sort of minimum wage, all within the construct of giving flexibility to workers that they want. All surveys showed that our drivers and some of the workers who work with Postmates, DoorDash, and others want to maintain that flexibility and why they joined the space. And so, I would encourage the folks in the audience here and others in the state to continue to lead as New York has done and innovate and find ways to make sure that people have that social safety net, but don't take away the flexibility that workers desire. I'd also say the one thing that I didn't talk about here is Philadelphia passed the National Domestic Workers Alliance passed a portable benefits fund in the city of Philadelphia that hasn't taken effect yet, but also does pay time off in a creative way, allowing workers to bank that, use that money for retirement and for other benefits as well. And that's another way that cities and local government are innovating and trying to find a way to adopt the social safety net to the changing nature of work. Thank you.
thanks, Josh. Very, very informative. Let's wrap it up now with Terry Gerstein and her perspective on all of this.
Thank you. Thanks for the opportunity to speak today. I know we're getting close to our 1 hour mark.
Well, we'll go over, Terry.
Okay.
We were going to have to go over. So
I wasn't going to be able to speak that fast. I was just going to ask people to, I think it's useful to hear a little bit more about the worker perspective on these topics. And And maybe I'll start out with a couple of things. One is just noting I worked in New York State government for many years at the Attorney General's office and the State Department of Labor. And I took great pride in New York's leadership and in New York's innovation. And you know, the innovation that I really take a lot of inspiration from is of Francis Perkins and of all of the state's developments after the Triangle Shirtwaist Fire, and the state being one of the first in the nation to really protect workers at a time when many were getting sick and dying. And that's the tradition of New York innovation that I think is really needed right now. Really vigorous and robust protection for working people who are more vulnerable than ever. So I just want to start out by questioning, we started out with a discussion of, you know, what is the gig economy? And I just want to question that premise a little bit because Handy is a cleaning company. Uber and Lyft are transportation companies. Instacart is a delivery company. There's not an industry that's like the gig economy. The only thing that is really different about them, the jobs they create are jobs like any other. The only thing that's different is the customer gets the service through an app. And so I just want to note that sort of framing of it, I think, is a little misleading. And I want to start out by really framing why employee classification as employee versus independent contractor matters. And the basic issue, and this has been sort of implicit in all of the prior presentations, but hasn't really been explicitly stated, the major issue is that workplace laws cover employees and not independent contractors. So we've talked a little bit about workers' comp and the Black Card Fund or unemployment insurance, but every single workplace law covers employees and almost without exception does not cover independent contractors. So what does that mean? That means wage and hour laws. That means the minimum wage. That means there is no wage floor at all. I use Twitter a little more than any healthy person should. And I see a lot of people of Instacart workers, Postmates drivers sharing screenshots of the amount of money that they're paid for the work. And when I say that the minimum wage means there's no wage floor, it means there is no wage floor. People can be offered really minimal, frankly, de minimis amounts of money for work that lasts, you know, a half hour to 45 minutes. It means no overtime. It means the requirement that that employers can't take workers' tips, that doesn't apply. And in fact, the DC Attorney General sued DoorDash because they were basically using customer tips to satisfy the company's obligation. And the lawsuit was filed as a consumer protection law because accepting the premise that the workers were independent contractors, the labor laws don't protect them. The non-tip stealing laws don't protect them. Laws about timely payment of wages. Again, we've talked about unemployment insurance, which is now being such a crucial lifeline for the millions of people who've applied for it. The way the system works is that employers pay unemployment taxes quarterly. It's actually a pretty modest amount. It's only on the first $10,000 to $12,000 or $14,000 of wages a year, and the average amount is, I think, in New York, I think is something like 4%. And what that does is it creates a fund so that when workers are unemployed through no fault of their own, either they were terminated but didn't commit misconduct, or they voluntarily quit with good cause, they can get some amount of money during the time that they're unemployed. And the way the whole system works is employers are supposed to pay in. We've already discussed a little bit the sort of complicated situation that has been set up by the federal unemployment law. But setting aside the issue of the pandemic, for years and years until this unique situation, workers who were misclassified did not get access to unemployment insurance or had to struggle mightily to get classified appropriately. Workers' compensation, again, workers who are misclassified, who are treated as independent contractors instead of employees, don't get access to workers' comp if they're injured on the job. What does that mean now for workers during the pandemic who are exposed to COVID through their work? If someone is completely isolating but is an essential worker and is exposed through work, that person wouldn't have access to workers' comp. Paid sick leave, paid family leave. Again, paid sick leave, something that's crucial at all times, but even more so now. only employees have the right to paid sick leave. One thing that people don't talk about that much is anti-discrimination laws. The anti-discrimination laws that the EEOC enforces, that state and local agencies enforce, only cover employees. So what does this mean? This means that, and again, this is little noted, but that these companies, there is a prohibition against contracting, against race discrimination in contracting, but really, there's not really a prohibition against other kinds of discrimination. If they wanted to say we won't hire drivers of a certain religion, there's not really much of a claim there. There's not really anything that would be stopping a company that has independent contractors. And then the various, all of the laws at the federal level, OSHA, the safety and health law, only covers employees, which means that if companies have independent contractors and not employees, any personal protective equipment they provide is just magnanimous. They have no legal obligation to provide PPE. Similarly, the right to organize applies to employees and not independent contractors. And in all of this, workers being retaliated against, there's very high incidences of workers being retaliated against for complaining of violations. And again, those anti-retaliation laws only apply to employees and not independent contractors. And in addition, any access to government help, like the Department of Labor, if you're not paid, that doesn't apply if you're an independent contractor, because you're not an employee, you're not covered by those laws. So I think that if you just look at the sum total, you just see there's an entire structure, and our structure for protecting workers is significantly less than most other developed countries, but it is what it is, and these are crucial lifelines, and they really do not protect. They really don't protect people who are working as independent contractors. I would note as well that there is a significant impact, in addition to the impact on workers, on companies that comply with the law and classify workers properly, because they have to compete with companies that are experiencing substantial savings as a result of misclassifying workers. So as I mentioned, COVID demonstrates the real, and Vina mentioned as well, the real impact of people being treated as independent contractors. They don't get paid sick leave. They don't get personal protective equipment, except, if the company decides that they want to do it, but not as an obligation, no workers' comp, and problems with unemployment insurance. So what are in New York, the laws, there are various tests that are used for employee status. And, depending on the law, the wage and hour, the workers' comp, the unemployment laws, the way I describe it to people is that these tests are different. They all look at multiple factors, but if I read them all out loud to my mom, who's a retired second grade teacher, she would say, I don't hear any difference. You just said the same thing 3 times. So they'll look at overlapping similar factors related to control. The test that was incorporated in California in AB5, the ABC test, is a test that I think most worker advocates and also most people in government enforcement really prefer. And the reason is that it creates a really clear, manageable, understandable test. It's only 3 factors to look at, and it's sort of very straightforward. I would note also New York already has the ABC test in relation to 2 particular industries, the construction industry Fair Play Act and the transportation goods Fair Play Act, both already incorporate the ABC test. So New York courts and judges and the unemployment system, the Department of Labor and the construction and transportation, there are industries that are accustomed, and government agencies and workers who've already been operating under the ABC test. In addition, New Jersey already has the ABC test, and Massachusetts as well for wage and hour. The B prong, as Vina pointed out, is really a critical piece of it. That it's out, that the work has to be part of the usual course of business of the company. And I know that in some instances that some of the transportation companies have said, well, Uber, Lyft have said, well, we're not a transportation business, we're a technology business, and we're just matching people with, drivers. And I just think if you sort of analogize this to the airline industry, it becomes clear just how problematic that approach is. Like, could you imagine a universe in which the pilot has to buy their own airplane, and the airlines say, well, we just match customers who want to fly places with pilots who want to fly them there. Like, obviously drivers are integral to these companies' businesses, and they could not operate without them. The status of recent case law in New York is that there is a case, there have been cases involving Uber at the appellate division, finding workers to be employees. And in addition, just a couple of months ago, there was a case involving a Postmates worker, again, coming up, emerging in the unemployment insurance context. And that worker was found to be an employee. The New York Court of Appeals upheld the determination by the Department of Labor that the worker was an employee. And in the ruling, they found that Postmates exercises more than incidental control over its couriers, low-paid workers performing unskilled labor who possess limited discretion over how to do their jobs. That they retain some independence to choose their schedule and delivery route doesn't mean they have actual control over their work or the service that Postmates provides to its customers. And the court analogizes to a case from a number of years ago in which it was also a delivery company, but it was pre-internet. And the court actually says, although the operative technology has changed in the interim decades, the case is indistinguishable. Richard, I see you're about to tell me.
Yeah, I think we're sort of running out of time. In fact, we're over already.
Okay, I will wrap up in 2 minutes.
Okay, sure.
One is just to note that there's a lot of action on these issues elsewhere. In addition to California, New Jersey issued a demand to Uber for $649 million for failure to pay unemployment taxes. The Massachusetts AG's office has settled several cases involving gig economy companies, one that placed dental workers, another teachers, requiring them to be reclassified as employees, as well as considerable action at the municipal level, like the TLC wage rule that Josh spoke about, which most of the transportation companies opposed when it was proposed. I just want to note a few final thoughts. One is questions about flexibility. This is a little bit of a false dichotomy. Flexibility is not inconsistent with employment. You can have flexibility as to work hours and still be an employee. I imagine there are a number of professors on this webinar who have flexibility and still are employees. In terms of innovation, throughout our country's history, people have been wildly innovative within the constraints of actual laws protecting workers. And I would also note, in terms of fairness, that every employer in New York State has to follow the workplace laws. The bodega on the corner in Brooklyn, a family-owned diner, these tiny employers and companies have to pay their unemployment taxes, get workers' comp insurance. And it just seems, as a matter of basic fairness, a little bit problematic that large multinational companies would not have to. And my final thought, two final thoughts. One is just that it's bad for public, in addition to the impact on workers, it is bad for public health to have companies disclaiming responsibility for their workers. If a company is disclaiming the responsibility to train people, train them to provide paid sick leave, to provide PPE, I think the pandemic demonstrates that this is a situation that is bad for the general public. And then my final thought is that, all of this just makes me profoundly sad, because it doesn't have to be this way. These are innovative companies. They provide a valuable service. Some of them are doing really great financially in their business volume right now, like Instacart during the pandemic, and they're not improving working conditions. I mean, I live in New York City. Uber is convenient. I send my mom groceries through Instacart so she doesn't have to go to the supermarket. These companies could be amazing. They could be providing a great service to customers while also providing workers with really good jobs. And they could take pride in creating good quality jobs. And I just hope in the future that they'll change course and take an approach in which providing really strong, solid, family-sustaining jobs is something that is also a focus.
Well, thank you, Terry, and thank you for all of the panelists for really excellent presentations. We've run over, but Avi, you want to do a few questions?
Sure, and let me just say thank you to Vina. She had to go because of a childcare arrangement, and she wanted everyone to know how much she enjoyed the panel, and I'm certainly very, very grateful for her participation in it. So to anyone in the audience who wants to submit a question, let me just remind you, you can use the Q&A button at the bottom of your screen. We've gotten a couple of questions during the session. there are just two that are still outstanding. So one is from Dan Feintuck, who asks, how do you account for people such as contract attorneys or contract white-collar employees, where the firm or government agency hires a third-party agency to legally employ their workers in order to get around giving full benefits? Why would those people not be considered gig workers? This is really common for lawyers, tech employees, and government workers. And the other question that we've seen come through is, Florence Abrams says, more comment than question. It seems as though, ironically, these new work arrangements are creating more need for a socialistic worker protections system. What's the panelists' view? So Richard, I'll leave it to you how to distribute that.
I'm happy to take on the first question about employees being, about workers working for contract agencies, which is to note that, I mean, that's more of a policy issue, because if they're working for agencies and they're being treated as employees by a placement agency or a temp agency, they're in legal compliance with the law. Through the temp agency or the placement agency, the agency is paying unemployment, is paying workers' comp, is ensuring that they're protected in terms of, they have protection from, of all the various laws. It's more of a public policy concern, because there are studies showing that temp workers make significantly less money than other workers. And I recently learned, read a great deal about temp worker laws, and learned that in other countries, there are totally different approaches where, for example, there might be a limitation on the amount of time that someone can be hired as a temp worker or a contract worker before they have to be brought on as a full-time employee, or limits on the total number of contract or temp workers, that the percentage that a company can have. So that was really eye-opening for me in terms of like a very different approach. But from a legal compliance perspective, not a policy perspective, as long as someone is paying, they're being issued a W-2 and someone is paying all of the required taxes, it's not necessarily a violation. I don't know if there would be ERISA concerns, but maybe one of the other panelists might know about that.
To the second
I thought
question,
other people wanted to respond to that. Yeah.
to the second question, I could jump in, and I think the question was about a socialistic response to employee protections. If that's a policy if that's a public policy that the state wants to take, or and they want to socialize these costs, that's one policy decision. But we're not being asked to do that. We're being asked to socialize these costs across employers. And employers have the ability to move, to leave, to find states with other policies that are more attractive for their business, and they do that on a regular basis from New York State. The population follows. They go to North Carolina, to Florida, to other places that have a different policy. So, one policy decision is to what degree the state wants to play that role, but that's not the role they're being asked. Businesses are being asked to play. Businesses are asked to bear the cost of these exclusively. But that's policy. Good.
Yeah, I think on that policy question, I think it's an interesting point. If you look at our, benefit packages in Europe, for example, which include maternity, paternity leave, jury service, severe sickness, inconvenience compensation, a whole host of other things that are allowed by the structures that exist in France and Germany and other places. That's something that I unfortunately, I think it would have to be done on the federal level, not on the local level, but it is, something that's worth considering. There's an author, an academic out of MIT who first authored, whose name I'm forgetting now, who authored Romney Care, which became Obamacare, which talks about the social insurance fund and a model of, like that, which I do think could play a role in the conversation. Okay,
well, there's just one more question that's come in, which I I guess is as good a note as any to end on if that's where we are. But I guess my question, the question is about mobility and the point that Frank just raised about employers moving across state lines. And the question is, to what extent is that true with internet-based companies, app-based companies like Uber and Lyft? Is there a realistic danger that, you know, Uber, for example, would leave New York State, or that some of the other new economy online apps, or is there less exposure to that risk with new economy companies?
Josh can handle that, but I know Uber wasn't in New York State, outside of New York City, until just recently. So it's they seem to be fine. That, I don't know if that's the appropriate Uber take on that, but Uber outside of New York State is a new development. So mobility, I guess, is they could leave New York or reduce their services. And these are valuable services. We have nursing home care agencies that the only way these home health aides can get to places in Chautauqua County and Allegheny County are through Uber services. So upstate New York, they're essential in some places. We focus a lot on Uber in New York City, but we're a big state with a lot of needs and a lot of issues.
All right. Does anybody else want to have a last word on these or other issues?
I would just add on sort of thinking about both of the last two questions together. One is that, you know, this question of leaving, you know, the concern about companies leaving the state because of protective labor laws. I think that there's, you know, that's not really a question to sort of, you know, shoot from the hip in terms of like one or another company, what it might do. But I would just note that, for example, you know, the dominant economic thought was that raising the minimum wage would reduce employment. And then there have been studies repeatedly over and over again that, you know, initially by a Princeton economist who sort of did the seminal study comparing two states where one raised the minimum wage and one didn't. And those studies found that, you know what, raising the minimum wage really does not increase unemployment. And that there are like, obviously like small, you know, there's always more research to be done, but like most of the studies and meta studies on that have found that it doesn't. And I think if you look at the states that where, you know, people are really thriving and where there's more, you know, in terms of education and health and you know, all kinds of indicators, generally they're states that are more protective of their people. And in terms of the socialism question, I mean, I think, you know, we socialize a lot of things. Like a park is socialized land, right? Like the library, all of these, you know, in the purest sense, it's a collective endeavor. Social Security, which has massively widespread public support, is a social insurance program. And, you know, I think another way of asking this is, why should these workers, why should these drivers, to the extent these are useful services, and again, like, I think they're great services, you know, they're very convenient, they provide a great customer experience, but why should the worker, instead of the costs being, like, why should the allocation of the costs be on the workers having really degraded job conditions and really, really difficult lives?
Right, so I think I want to thank everybody. We've gone significantly over time. I'm grateful to those panelists who were able to stay. Richard, do you want the last word?
Well, I just, again, I thank everybody for attending. I thank all of the panelists who've stayed overtime, which is appreciated. And thank you for an excellent, excellent discussion.
Yeah. Thanks so much, everyone. I can't imagine a better panel, and I'm very grateful to everyone who made time to make this possible. Thanks so much, and we'll see you next time, I guess.
Thank you.
Okay, bye-bye.